Hello, everyone. Welcome to today's session. We are Indian startups. We are a strong community of more than 90,000 members, and we conduct sessions where we invite industry experts. So we conduct speaker sessions as well as workshops. And workshops are something that goes on for more than one day, and for a longer period of time as well. So our motto is to make entrepreneurship affordable by connecting the everybody in the ecosystem with the right person. And yeah, we are socially available, and like available to connect with everyone through these through these platforms. And we will really like to know if you are interested in speaker sessions, to volunteer for for webinars, and if you're interested in workshops, just you can let us know. So we'll be sharing the links during the session in the chat window, where you can register yourself as a speaker, as a volunteer, and we'll be sharing what is happening right now as well. So these are some upcoming sessions. Like there is a workshop which is, and also some workshops that are going on, workshops like design sprints and things like those. So we'll share these details, during the session with you as well. And for today, like on the same lines, we have Mr. Siddhant Pandey from Law Briefcase. So he'll be discussing about a very sensitive topic and a very important step for a startup, a co-founder agreement. And he'll be talking with us, from a perspective of emotions and the law. So Siddhant, welcome to today's session, and you're heartily welcome. And like over to you now.
Hi. Thank you, Jatin. Hello, everyone. Thank you for being present here. So, as Jatin has already explained, that we will be discussing co-founders agreement, and this is a very sensitive topic. And we have come up with the name "Save Your Business and Your Friendship," and we have a story to tell here. Let me just share my screen, and Jatin, kindly allow me
Yeah,
to do that.
yeah, you can
All
do
right.
that right now. Yeah.
All right. Wonderful. All right. So, co-founders agreement, save your business and your friendship. So, before we begin to discuss what is the premise of this, I would like to tell you guys a little story. So, I have a friend. I won't take the names of the people involved in this story because of privacy concerns. So, this friend comes up to me and he tells me that his neighbor came to him and they discussed the idea to to come up with a startup where they were going to be aggregators for labs, let's say, or pathology labs or radiology labs. They wanted to be an aggregator for them. They decided to come up with an app, and they discussed their ideas, they improvised, and this was the point where they should have come up with a co-founders agreement, but they did not. They did not realize that they can have something like that to ascertain their roles, powers, duties, and their rights. But anyway, the story continued, and this friend of mine, he prepared the POC for the startup. The proof of concept was prepared by him. He also went out and looked for investors, and he even got an investor to start investing in the startup. The first investment they got was probably around 10 lakhs. And as far as I can recall, the investor was willing to give it in two parts, 5 lakhs in the first and the second, and 5 lakhs in the other half. So now this is where conflict started to arise. The neighbor, who is also the co-founder, was interested in more funding. However, they did not discuss this. It was during the time of elections, and this neighbor is a journalist, so he had to go out. So during this period when the election was going on, the co-founders did not communicate well. They couldn't do that. My friend tried to get the other person talking about the agreement, about the registration of the business, about the terms of partnership. However, they could not succeed. Now, what happened over a period of time was, after the elections were over, this friend came back, and he came to my friend and he told him that, hey, congratulate me. And my friend was like, why, what happened? And this neighbor, the co-founder, he explained that, okay, I have registered my company, and this is the name. This is the paper which shows that I have incorporated it, and I have shed out 30% equity for an amount of 30 lakhs, in which I've already received 15 lakhs, and here is the paperwork. Now, this friend of mine, he was astonished. He was furious, and however, he decided not to act on his anger. He waited, he waited, and this co-founder still was not ready to give any equity to my friend, and my friend was in a very desperate situation. Now my friend started his own startup in the similar industry, having the same model but with a little less investment. However, my friend was more capable with his soft skills and with his technical know-how. He gathered around 20 to 25 people for this purpose. He gathered engineers, he gathered UX and UI designers, and he did all of that without getting any investment. However, he lagged where he had to market his product. He lagged where he had to, where the cash was required. So now he was in a desperate situation. He wanted to sell his application. He wanted to sell his business to the neighbor, but he couldn't do this because the neighbor was no more interested. He thought that he has the money and he doesn't need the co-founder anyway. Sometime later, the neighbor realized that he needs my friend. He came to my friend and they discussed a lot of things. However, they did not get the paperwork done. And here my friend thought that, okay, anyway, since that the neighbor has come to a realization, he will probably do it sooner or later and things are good to go. So my friend started working with him in his startup and he quit his own startup. So he built a product, he quit it, he started working with the neighbor who betrayed him in the first place. And now this neighbor, the co-founder, he did not turn up to pay him the salary he promised. Now this is where things get really bad. Now my friend on now my friend came up to me. He explained his whole problem. I had a really long conversation with him, and there was a point where I realized that this friend who used to think of the neighbor as a good friend now is the sworn enemy of this man, and they cannot sit together in a room. Forget the friendship. My friend does not have a business, and the neighbor is not able to run the business because my friend has so many loopholes from the business that he cannot succeed. The neighbor cannot succeed. My friend has played his card in a way that the neighbor is liable for a lot of criminal actions. Now, this is where both of them have lost a friend and both of them have lost their business opportunities. So this is why we need to discuss why is it important to have a co-founders agreement in the first place. So I think I'm moving over to the next slide.
Okay. So
Let me
Siddhant,
know.
like, what is the reason, in your experiences, different cases that you've handled, as a lawyer, like, why is that? Why people tend to skip it and, don't give enough? Because this is like the most important thing when it comes to, building a startup, like one of the most important agreement that you can sign. So
Right.
why is it that, like, people tend to skip it, like, for later on?
So the number one reason being that a lot of people don't even know that a co-founder agreement exists. The number one issue is that a lot of young entrepreneurs, even experienced people who might be first time entrepreneurs, do not know. Number two could be that they probably know that there can be an agreement, but how do you frame it and what actually needs to be discussed and what are the clauses that are specific to a co-founders agreement? We are talking about startups here. The focus is on startups. A business is very different from a startup, so they might confuse it with partnership agreements as well. So we will be dealing these things in more detail as we proceed with the presentation. However, let me know if this doesn't satisfy the answer for now.
Okay, perfect.
All right, so moving on to the next slide. Key takeaways from this presentation, from this discussion, you'll be learning five things: the meaning of a startup and an entrepreneur, what exactly is in our agreement, and the documentation. I'll deal with the last two parts separately during the slide. So a startup is very different from a business, and the meaning which I find the most purposeful when I use the word startup is the one from Lean Startup. It's a good book. It has a very precise definition. We'll be discussing that in a little bit detail after this slide. And talking about entrepreneurs, entrepreneurs are not only the ones who are running startups. An entrepreneur is basically a man who solves problems. So everyone in that sense can be an entrepreneur. If you want to solve problems and you don't know the solution and you're still figuring it out, you are an entrepreneur. What exactly is an agreement? An agreement and a contract, right? They are two similar words. So in general, people can use them interchangeably. However, in the legal arena, in the legal industry, it's not possible. The judges have a real they have a distinguishing line here. Agreements are basically the ones which are not enforceable by law. Agreement could be, let's say,
Hello.
hello, yes. Okay, nothing. I think I heard some background noise. Anyway, okay, so an agreement is basically which is not enforceable by the law, whereas an agreement becomes contract when the courts they take it as a contract. As simple as that. But how do the courts decide whether an agreement is a contract? Now that is a question of law, and that is not really the concern of the entrepreneurs. However, they should know what they are doing. Being an entrepreneur involves knowing a little bit about almost everything. You cannot call yourself an entrepreneur if you are only an expert in one field. So anyway, moving on to documentation of agreements. Documentation of agreements basically refers to the way these documents are supposed to be drafted. They are different, or not all contracts are to be drafted in the same manner. So that's what we are going to discuss. Coming to the fourth and fifth point, I will also be discussing what kind of clauses should be there, some standard clauses, not only for general agreements, but also for co-founders agreements. And the fifth being force majeure and due diligence. I'll talk about due diligence before I speak about force majeure. So due diligence basically means that you're not supposed to be negligent. I will give you a good example about a doctor being negligent and how the law mandates around it. So we'll discuss that in detail. Coming to force majeure is basically the conditions of the future that you are able to see. How long is your foresight? That's all about force majeure. Basically, the unforeseen contingencies for which you need to prepare. So while drafting contracts as a lawyer, we have to prepare for everything. We are supposed to know when can the partners reach a point of impasse and what can be the most viable solution at that impasse. So that's what we are going to learn from this discussion. I'll be moving on to the next slide. Jatin, please let me know if there's anything that you need to speak about.
Yep.
All right. So talking about startups, entrepreneurs, and contracts, the premise has been set here. We'll be talking about startups, entrepreneurs, and contracts, and how exactly are they related. So before we dwell into the rest of this presentation, I would like to request you guys to understand these three things that have been written here. And these are not exactly the law. They are not exactly a fact. They are 3 points that you need to keep in mind. They are a form of a realization that you need to have in order to understand why is it important to have an agreement and what goes into it. So talking about that,
Okay.
things are always changing in business. So this is something which,
So
okay, please go ahead, Jatin.
okay. Yeah. So before we delve deeper into the different aspects of a co-founder agreement, so we'll be launching a short poll to understand more about our audience. So the poll is active now. We really request you to answer this like in a short time. Yeah. And Siddhant, you mentioned lean startups. Like
Right.
meanwhile this push the polls is being answered. Can you like just give an idea, like, because the agile term as a term, it's like it's in here like right at the moment, and since like quite a few years. So when it comes to co-founder agreement or legalities, so what do we mean by an agile startup in that context?
So basically, a lean startup is where you are constantly testing things. That is exactly what the book tends to deliver. You do not you ha- So basically, a lot of people when they are starting up, they feel like they're going to build the product first and then they're going to test it out. They're going to have a POC in place and then they are going to crowd
Mm-hmm.
in the field with it. When it comes to having a lean startup, you start with the bare minimum. You started right away. You do not wait for the POC. You start with whatever you have in your hand. Let's say if I want to start a service where I build contracts, I'm not talking about a startup here. Let's say a problem which is there to be solved is that people do not have a good co-founders agreement, and I'm trying to solve that. So now there are two ways. In a lean startup, what I would do is I would start with whatever knowledge I have, with whatever team I have, and with whatever target audience I have. I'll start with them right away instead of waiting for the period where I have more knowledge, where I have more resources, more teammates, more time. I will start right away so that I will be able to have constant interaction with my audience, where I will be able to understand what exactly is the need of the hour. So that is what a lean startup
So
is.
it's like it's more like learning as you go.
Right, exactly.
Okay,
That's a
great.
really good way to say that.
Great, great. So we'll be ending our polls now, and so so from the result that we can see that today we have lots of entrepreneurs who have joined us today, and like more than 70% of the people are either aspiring entrepreneurs or or like on or already on their entrepreneur journey. So so seems like we have a very relevant audience to the to the topic today, and we're expecting some a lot of questions from your side, keeping that in mind, so because basically you all guys are in that stage. So thank you for answering the polls. So we'll be ending the polls now, and then Siddhant will be taking us deeper into different aspects of a co-founder agreement. So Siddhant, we are good to go now. Yeah.
All right. Thank you so much, Jatin. So, guys, as I was speaking about startups, entrepreneurs, and contracts, how these things are related, and what are the three realizations that you need to have before starting this discussion ahead. All right. So, speaking of why things are always changing in the business, you need to realize that emotions and human factors are always there. No matter how much you try to automate, you must have read in these books, Rich Dad, Poor Dad, and all the other people who are following these books. They will tell you that you need to automate things. You need to automate things. You need this many revenue streams, right? But then again, there are certain things that you can never automate. The human factor can never be eliminated. And since humans are ever evolving, ever changing, this cannot be eliminated. You have to prepare for the worst. You have to. That is the only way. Or else you might end up losing your friend or your business. You might even end up hating your co-founder and your friend. There's no point in losing both of them. You can save both of them if you have the right things at your disposal. Moving on to the other one, we talk about how the law of contracts work in the real world. So the law of contracts is taught to law students from the initial stages of their studies, right? This is there for a purpose. The curriculum has been set like that for a purpose. The law of contracts is the basis for almost all the laws. Even if you read sociology, you learn about social contract theory. When you read psychology, you'll talk about people committing to each other. So commitments have to be in writing. If they are not in writing, there is no point, especially in business, right? So that's how we deal about it. And contracts not only go around in the field of getting things penned down, they are also safeguard mechanisms in a lot of scenarios. For example, let's talk about terms of services at the footer of the websites and apps that you use. So the terms of services are also a form of contract. They are there to protect the business. They are there to protect the business and the owners. They are also there to let the users know what their rights are, what their liabilities are, and when can they be held liable for a misconduct or a fault or anything like that. So law of contracts work in a lot of areas of law and business. In fact, no business can be conducted without a proper contract in the first place. And it's not just a co-founders agreement. It can be a partnership deed. It can be a general agreement for service, or and let's say even a lease agreement. So law of contracts is almost everywhere that you see. Wherever you need a commitment, there is supposed to be a contract. So coming to the third point, we talk about why do great business ideas fail even when they are between friends. So I suppose this is fairly easy for everyone to understand that almost all the co-founders are friends. Businesses are always started amongst friends, right? Why would you want to get into business with a person you do not know? And gradually, as you sit and speak and talk with the co-founder, you become friends anyway, right? So we need to realize where is that gap where people tend to lack from succeeding. I wouldn't exactly call it a failure because it's always in your hand, right? For this discussion, we wouldn't even use the word failure. That sets a negative mindset in the first place. Moving on. Then let me know if there's anything that you need to let us know.
We are good. We are Siddhant. We are going good. We are
All
great.
right.
Yeah.
Thank you so much. So as we were speaking about the premise, startup, entrepreneurs, and contracts. Right. So a startup is the same definition as I discussed before. It's a company working to solve a problem where the solution is not obvious and success is not guaranteed. So you know what the problem is, but you are still trying to figure out the solution and you're constantly improvising, as Sathan reminded us. And now who is an entrepreneur? Entrepreneur is basically a person who's trying to build a profitable business or trying to solve a problem, right? And basically both of these things have to happen together. So an entrepreneur is trying to solve a problem and they're also trying to generate revenue out of it, right? Now, law of contract is something which you guys might not be aware. This is where my expertise will come in. Legal documentation that decides your rights, duties arising out of commitments. All the businesses are run on commitments, and these commitments are either based on emotions or what you have written down already, right? So your emotions are ever changing, but the things which you have already set in stone are they probably might not even change. You can have clauses in your agreement to modify the words or the commitments, but then again the paperwork has to be there. So we need to factor in emotions and the paperwork and the business and the problem that you're trying to solve. Now all of this can be solved. A startup can be protected, the entrepreneur's interest can be protected, and the contract laws can help us by having a co-founders agreement. So if you have a co-founders agreement, you can take care of all the problems that we have discussed so far. So Jatin, I think I'm good to go with this slide. I'll proceed further. Let me know if there's anything.
Yep. Okay. So as we move on, so we are getting now we have a basic understanding of what a startup is and what are the relevant terms, important things that are related to a startup, and what by definition is a co-founders agreement. I hope so we are at that point. So now I think so Siddhant now will be moving towards in more details of
Right.
how the legalities work, how what are the things you should consider while writing one.
Right.
So from now on, from the next slide, we'll be going more into depth. So is it correct, Siddhant, right?
Right. Indeed, of course.
Yeah. So we'll need Okay, great.
Moving on. So why do you need a legal agreement? As we discussed that there are going to be a lot of problems, emotions, and people, they are bound to change. We cannot rely on words without getting them in writing, right? You must have heard these things in movies. You must have heard these things from your mentors, your seniors, that always get things in writing, and that has been there for ages, and it is for a reason. Because when we start trusting the other person too much, we lose a sight of what can go wrong. So we need to prevent that from happening. We'll deal with it point wise. So let's speak about when we start a company amongst friends, we neglect paperwork. So you think that this is a friendship, and that how can you question your friend's moral compass, and how can you question whether he will be doing these things right, or does he have the relevant skills? Will he be able to execute the whole plan? Right? You might shy in some areas, you might not, but any which way you'll have to discuss everything. So you need to get rid of that shyness, and you need to proceed to discuss the paperwork. Fast-paced life, ever-changing business industry, and all things that can go wrong. Now this is something, this is the area where we talk about the force majeure, right? Things which can go wrong. So you need to sit down with your co-founders. In fact, if you have more than two, if you guys are more than a team of two, you need to sit with your co-founders, and you guys need to speak about everything that can go wrong. It will bring anxiety. Yes, talking about the future and being uncertain brings anxiety, but the anxiety is a feature of the human mind, so that it keeps you aware. It's there for a reason as well. So you will be anxious, you might have heated discussions or even arguments for that matter, but then again you will come out of it more strong, and you will come out with a clearer vision. And if not with a if you do not come out with an answer, at least you will know what the problem is that you guys might face, and it will make things a lot more easier, so that you can discuss your problems with other people in the team or any other mentor that you feel like, right? So that's there. So you need to think about the force majeure. Reasons why successful business run on legal documentations. I think I don't have to explain anything here, because all the businesses that we have seen, every business that we know of, every brand, every company that we know of, has to rely on paperwork. There is no other way. There is no other way that a businessman can say something and turn back against it without legal consequences if they have it in writing. So that is always there. Now, coming to the most important part of this particular slide, we talk about Section 10 of the Indian Contract Act. Now, the Indian Contract Act is the major law which runs the which basically is concerned with contracts and agreements in general. We do have the Partnership Act, and we do also have the Specific Relief Act. However, the being an entrepreneur, I really don't think it would be beneficial for you to delve really deep into the legalities. Rather than, you should be able to understand how the legal justice system works and how exactly is justice determined in the Indian legal system, and how do you make a good co-founders agreement, and also that no legal professional is able to um, dupe you into not realizing what exactly you're getting into. You always need to know what the law is and what are the documents that you are signing. What do they say? So that's why Section 10 is of prime importance here. So, 5 essentials for every contract. If you ask a law student or any lawyer, they will know what I'm talking about here. We have 5 essentials for every agreement. If they miss out any of these 5 essentials, it cannot be called a contract. And if it cannot be called a contract, you cannot enforce it before the courts of law. So it's as good as a napkin, right? There is no use if you cannot hold it against the person who signed it. So a good example would be um, an agreement. I think there's something. All right. So as I was speaking about it, these 5 essentials, they are important in every agreement. And a good example of something which sounds like a good, viable agreement, but is not a contract, would be, let's say, if I ask my friend to build weapons for me. Let's say I ask him to build guns for me, right? And I decide to pay him a certain amount, let's say XYZ. The amount really doesn't matter here. So my friend is going to be building he's going to be constructing and making weapons for me, and I'll be paying him, and that's the end of the agreement, right? We can get that in writing, and I can even get in specifications what kind of trigger do I want, and what is the what quality of the metal is that is required, and what kind of ammunition is required, and how should the delivery be made, and what is the time period in which he should be delivering these weapons. All of that can be written down, and we both can sign on it, but it won't be legal. It won't be ever called a contract. Why? Because it misses one essential out of the 5, and that essential which it misses is that we do not have a lawful object here. The object basically means that making guns is illegal, right? We have laws for making guns. The ordnance factory is there, right? And they have laws for making it, selling it, transporting it, and even using it, right? We have laws for everything related to guns. Now I just cannot go and get into an agreement to make guns with my friend. So that's how we look at all the agreements. And this was just a major example which law students are given in their law schools. This is for the entrepreneurs to understand, and this is for them to realize what they're going to do is legal or not. Talking about the 5 essentials, I'll just go to the next slide. And this is going to be a little technical. So bear with me if anything goes, if anything is ambiguous, let me know. Section 10 of the Indian Contract Act 1872. So I'll just read it out aloud. I hope you guys will be able to read it along with me. What agreements are contracts? All agreements are contracts if they are made by free consent of the parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. You will need some time to read it yourself before I explain it. I'll read the next part. Nothing herein contained shall affect any law in force in India, and not hereby expressly repealed, by which any contract is required to be made in writing or in presence of witness, or any law relating to the registration of documents. Now this is where it gets technical. I'll give everyone some time. Jatin, let me know if 30 seconds should be enough, or should we give more time?
Yeah, I think it's an important aspect when so let's give some time here, and then we can accelerate. So we have some 10 minutes which we have at our hand for the presentation. Yeah.
All right, let me know that, and then let everyone know, in fact, when the time for reading would be about to be over.
Yeah, we have good 10 minutes to cover, cover the future slides. Yeah.
All right. So basically, what everyone
Yeah.
needs to look here is that I have highlighted a few phrases, and these phrases will be explained in a much better way in the next slide. For now, I just want everyone to see that there are 5 things that I've highlighted. Number one being free consent. Number two being competent to contract. Number three being lawful consideration. Number four being lawful object. Number five being not expressly declared to be void. So moving on to the next slide, I will discuss them in a little bit more detail. All right. Learning to identify if your agreement is legally binding. All agreements are not contracts. This is something which you must always bear in mind. All agreements are not contract. I might be able to get into an agreement with a friend to make guns for me, but it will never be called a contract. But all contracts will definitely be an agreement, because if they it could only become a contract if it was an agreement in first place with the 5 essentials that I have laid down here, right? So what are these 5 essentials? Going to detail them a little bit in more detail. Free consent of the parties. When I speak about free consent, what I mean here is that the party should not be under any physical pressure or mental pressure. They should not be coerced, blackmailed, either emotionally or physically. They should not be put in fear of any kind. They should be able to understand what the agreement is talking about, what the terms are, and when they are signing it, they should have their free consent, right? That is all we mean here by free consent. We have judgments and precedents over it. There are plethora of ways to decide whether free consent was there or not, but we cannot go into detail in that, because that would need at least 5 lectures as I speak about it. So coming to the next point, competency. When we speak about competency, some people might confuse it with competency of the co-founder, right? So it's not there. We are specifically talking about the law. This applies to every agreement, no matter what kind of agreement it is. So competency here basically means that the people who are signing, the parties to the agreement, they are of legal age. They are above the age of 18 years, and they are of sound mind, right? They should be sane while signing the document. That's what the competency talks about. Competency also talks about their legal ability to get into a contract. Let's say, being an employee, I am not allowed to get into an agreement with the client of my employer. I am not competent. So that is another way to look at competency. So apart from the legal age and the um, soundness of the mind, we also talk about competency in general, if it is allowed by the law, or if they are barred by the law to get into that kind of agreement, right? Coming to the next point, we talk about lawful consideration. Now, consideration is something which you are given in exchange, right? So let's say I have a lease agreement. I'm taking this place for lease from the lessee, right? From the lesser, right? So now in this case, what am I supposed to give them for consideration in return for this premise? In general, I will be giving him money, right? Money is a legal tender, so it is a lawful consideration, right? But let's say I tell him that um, I will pay you with ammunitions. You give me this premise, and I will pay you in ammunitions, right? I will give you bullets, and I'll give you a lot of, let's say, RDX, for example. That cannot be done, because that is not a legal tender. The consideration is not legal. Now, if there could be an agreement, let's say in the sense of a co-founders agreement, where I will be giving my premise to you as a co-founder to use it for the company's office. What will you be giving me in return? Right now, during the co-founders agreement, we'll have to figure out whether the consideration which is between the parties is legal or not. And trust me, this becomes very technical when it comes to the point of deciding the roles and powers along with the consideration that you're giving. Talking about lawful object basically refers to what I was discussing in the previous slide. Basically, what you're gonna do is lawful. It's not illegal, right? And this fifth point, it says not barred by law. So the law which I'm talking about here is the law of contracts, not the law in general where we're talking about what is illegal and legal. So there are certain contingencies with the contract act has already seen, and it has barred such scenarios. For example, the contract act has clearly laid down that you cannot sign a contract with anyone for giving your daughter's hand. This is just an example. We have a plethora of laws for situations like these. So, five considerations, I'm going to repeat them very quickly. Pre-consent, which basically means that the parties should not be under any pressure, be it physical or mental. They should be able to do it freely without any burden. Competency talks about their legal age, soundness of mind, and their legal competency, whether they can sign the document or not. Lawful consideration talks about the exchange that is happening between the parties to the contract. Lawful object talks about the purpose of the contract. It should be legal, right? And the last one talks about the contingencies that has been given in the Contract Act, so they are not barred by the Indian Contract Act. Then I'll be moving on to the next slide. Let me know if there is anything that you need to discuss.
Yeah, so like I think it's a lot of heavy lifting in terms of the technicalities and the terms that are related to any agreement or any legal binding that you are going into. But we should not forget that it's very important, because we cannot leave any guesswork when you are building the contract. Like a good contract is always straight. That's why we need to go into these sort of technicalities, but it's okay. We there is nothing to be afraid of. So we have Siddhant. So like so lawyers understand, and they understand it on the human factor and how, what sort of law that is there which relates to that emotion or that understanding between the founders. So that is why a good co-founder agreement is it's important, so that there is no guesswork. It's very strict. Did I get it right?
Right. That was bang on. That was bang on.
Okay. Yeah.
All right. Moving further ahead, what we have is that you need to decide your roles. Let me just move it a little further. I think it's more visible now, right?
Yeah.
All right. So as the slide speaks about it, that we understand that it is sometimes uncomfortable to discuss legal issues. It's not really the best thing to discuss with your partner, right? However, you might be able to understand once you do it that lawyers have to do it every time, right? We do it all the time. We have been trained to do this. We have seen partnerships failing due to not having these discussions. And we have also had people sit alongside with us and discuss their problem and discuss what can go wrong and what should they be able to do when things go wrong, right? So you have to be prepared. So you need to discuss and you need to come out of it together if ever a problem arises. So what you need to do here is, with the co-founders agreement, the main purpose of a co-founders agreement here is to legally decide your roles in the business. This is where it gets important, and I want everyone to pay attention here. You need to decide your roles early on, right? And this will decide the equity. The amount of work, the amount of effort, the amount of input you put in the startup decides your equity. It really does not matter who came up with the idea, right? Let's say I came up with the idea, and my friend here is good at executing it. He's good with SEO, he's good with copywriting, he's good with social media, and he's good with selling, right? And I am building the product here, and he can do everything else apart from building the product. Now, this is the area where we need to decide who holds power and who decides in what areas and who decides the veto, right? Now, talking about this, we come to the discussion on power balance and decision making. So you need to make decisions in a way so that the damage is minimized, because decision making usually comes in the form of a place where you are in damage control, right? The co-founders agreement will be most beneficial when you will reach an impasse. Otherwise, you already know what your roles and your duties are, right? So let's say my co-founder here will be managing the HR and will be managing the SEO and all the digital marketing related services, and I will be the in charge of, let's say, building the product and testing it out and getting the user testing done, right? However, my friend also has the liability and responsibility of making sure that the user experience and the user interface of the product or service, whatever I'm building, is good. So my co-founder here has a lot of decision making to do, and my job here only is to only build a product, right? And I, being an entrepreneur, I realize that building the product is never sufficient. The people who are good at selling can even sell the air, right? I have seen people selling these boxes full of air, and they market it so well and people buy it. $10 for free air. Who pays? Nobody. You must have seen balloons, right? Anyone can do anything if they have the right selling skills, and merely building the product does not really make your startup successful. I've seen a lot of people fail because they think that their product is so good that people will come and buy it on their own. But what they don't realize is that they need good marketing. And now here, this is my co-founder's job. So I would want to give him more equity, but then I would like to discuss this with him because I also want to keep more equity. Now, this is the point where I will sit with him and I will discuss that, my friend, this is what I'm going to do, this is what I want, and this is what I feel. Now you tell me if you think that I am wrong, if you think that what I'm speaking about is incorrect or is not justiciable. So that's the kind of discussion that you need to have. And when it comes to future and force majeure, even even the lawyers, even the best professionals will not be able to make your business successful until and unless you have decided what you're going to do when things go wrong, until and unless you have sat with your co-founders, with your partners, that these and these things can go wrong. You need to prepare a flow chart that if this goes wrong, we'll move in this direction. If this also goes wrong, then we will move in this direction, so on and so forth. You need to do that to be a good entrepreneur, right? And a professional can only help you with this, but then you need to gather the courage to sit with your partner and have this discussion. Do not shy away from it, or you will have a friend who can hold so many cards against you, and you will not be able to have your friendship good or your business do good. So that's all about this slide. Let me know, Jatin, if there's anything that you need to speak about.
So I think so we are very much deep into the discussion. So, and also there are some questions regarding the cost of a co-founder agreement.
All right.
So let me share it with everyone. Like for today's audience, so I'm sharing. So this is the link that I'm sharing where you can register for for a co-founder agreement uh, if you want to get one. And with that, we also have a special discount that will be applicable till this session ends. So it's a 40% discount on the standard cost of 8,000 rupees. So we really encourage you to go ahead and see if it's relevant for you. And Siddhant, so so now now we are moving towards the conclusion, and so in, let's say, in 5 minutes we'll be wrapping up all the slides,
Indeed.
and then we'll be moving on to the Q&A session. So
right.
we have some questions from the audience side that we want to understand. So
Wonderful,
yeah,
wonderful.
yeah.
So I'll just go on. Sorry. So 70% partnerships fail owing to the lack of due diligence. I hope you all can recall that we spoke about due diligence in the beginning. Due diligence basically means not being negligent, right? So I'll tell you, there is one thing called a mistake of law, and there is one thing called mistake of fact, right? And we'll come to discuss more about it, but keep in mind what I'm going to speak about force majeure for right now. A doctor, let's say, while conducting a surgery, leaves his finger, what do you call it, a ring, right? Leaves a finger ring in the stomach of the person who he was operating on. And now it has been there for, let's say, some time, let's say a week. And now this man who was being operated by this doctor is going to press charges against the doctor, right? So do you think the doctor did that on purpose, or would he done that on purpose? I think for this, I don't think I really can get answers from all of you. Jatin, let me know if there's a way to
Yeah,
get
so
answers.
so this is more like negligence, from a
Right.
professional side.
So So when a professional commits a mistake, when you commit negligence, the law is never going to be on your side, right? The doctor committed negligence, it was his duty. Due diligence basically means that while you are on your job, while you are doing what you're supposed to do, the work for which you are known, the work for which you are called a professional, you cannot commit negligence in that. If you commit negligence, you will be liable for that. So if a doctor leaves a ring in the stomach of the patient who he was operating on, the doctor will have to pay. And more specifically, the hospital who has employed the doctor will have to pay, because we also have a concept of vicarious liabilities. This also in a way comes close to the concept of mutual agency. Just like the master is liable for the servant's mistakes, the partners are liable for the other partner's mistake. So you need to be careful that your partners are not negligent. And if they are negligent, make sure that you do not ratify their negligent behavior, and that the business does not suffer or you do not suffer. Because negligence can not only be civil, it can also be criminal. You need to take care of that. And when I say 70% partnerships fail owing to lack of due diligence, it also factors in the part where partners do not discuss the force majeure. I mean, the things which can go wrong. They need to sit with each other and discuss that, and they need to decide what is the best way forward.
Hello. Hello, everyone. I think there is some some lag from the speaker side, so we'll wait for some time till it gets resolved. Yeah. So we're back. Yes, you can.
Went bad with the network. Jatin, can
Yeah.
you let me know what was the last part that you guys could hear?
Okay. So so we're discussing about the force majeure, the act of God, and why it is important to consider some things in detail in advance, during the due diligence and things like those. So when we are defining what needs to be go in in stone. That
All right. So basically, force majeure, due diligence, and having a frank discussion with your partner is what is important. If you don't have these things, you're more likely to not have a document where everything has been covered. Force majeure does not exactly is called an act of God, Jatin. So force majeure is basically things which you uh, think can happen, and you can prepare for that. It's a Latin term. When we study law, it is explained in much more detail. And I want to discuss it in detail. However, we have a time constraint, so we can probably take questions about that in a while if anyone has a confusion, right?
sure.
Moving on, important clauses that you must have in your co-founders agreement. So the first part deals with equity, IPR, duties, and vesting. So I'll deal with them very quickly. Equity is something which all of us must generally speak about as how much percentage are you getting, right? How much percentage of the profits will you be sharing with your co-founder? And it also talks about the shares, right? Uh, Talking a little bit about corporate laws, a share is basically, let's say you have 100 rupees as your company's evaluation, and you decide to make 10 shares out of it. You could have also decided to make 100 shares out of it, but the value of each share would decrease as you increase the number of divisions, right? So as your company's valuation will grow, you would want to have more shares, and these shares together, if owned from different companies, they're called stocks. So do not confuse stocks with shares. I just picked use the word stock so that you guys are clear about this. So shares, let's say I decide that 40% shares of my company will remain with me, and 30% will go with the co-founder, and the rest of it goes to the investor or the employees if we are talking about vesting of shares in employees as well. And this is something which you need to have in your document for sure. Otherwise, what is the point, right? So you definitely need a discussion on equity in the co-founders agreement. You need to decide this early on. Talking about the IPR, which is the intellectual property rights, basically the trademarks, the copyrights, and the patents, right? So these things have to be discussed. Let's say I am the one who's making this, I'm inventing something. This invention is my invention. Why would I want to go it to the company's name, or do I want it to go to the company's name? You need to have that discussion with your partner, and you need to discuss the pros and cons. Talking about IPR, the pros and cons in general would be, let's say, if I think about my personal interest, I would want to keep the IPR with me, because that will give me more control over the company in the future if I ever have a dispute. So I keep the IPR under my name. I give a license to use that IPR to the company. That's how I would prefer to work. But my co-founder might have a different opinion. He might also want to save himself. He might want you to give a certain license to him as well, so that he is not excluded and he does not feel the insecurity that you might take over the business, or you might take the name away that you guys have built together. And then you can just use the name, and he will have to start the same business with another name, and you will just be able to leverage all that effort seamlessly. Talking about duties, you need to decide what are the duties of each partner. Who hires and who fires, who brings the investment, who talks to the investors, who makes the presentations, who goes out, who does the field work, who makes who's gonna talk to the professionals, let's say lawyers, digital marketing experts, or let's say where are the areas where you guys are supposed to take decisions together, right? Now, we're going to talk briefly about vesting. Vesting is the concept where, let's say, I decide that I'm going to keep uh, 50% of the equity, and my co-founder is going to keep the rest of the 50%. However, if I give my co-founder my business here. How do you avoid that? You say that, okay, I am going to keep 50%, you're also going to keep 50%. Let's make it like this. The Let's say we take 10% every year. So for every year that you have worked on, or for every month that you have worked on, you get this much percentage, right? So let's say for working for a year in the startup with me, my co-founder gets 10% equity. After working for 2 years, his equity becomes 20%. After working for 3 years, it becomes 30%. 4 years, 40, 5 years, 50, so on. And now after 5 years, he's free to quit. And I wouldn't have anything to feel bad, because I know that he has been with me for 5 years. He has given me 5 years of his life. He's given the business 5 years of his life. He is now free to go, and he can reap the benefits of his effort. So can I. So this is supposed to be there for a number of reasons. So a vesting can or cannot be there. It just depends on the dynamics, the business, the industry, how you guys want to do it. It's just a thing which is there in this industry, and I wanted to bring this to your notice. Moving on with lock-in periods, notices, powers, and veto. So the period, let's say, of 5 years you were talking about in the earlier discussion for vesting, that 5 year period will be called a lock-in period, and it can be there with or without vesting as well, right? Let's say I get into an agreement with my friend and I ask him that you're going to work with me as an HR for at least 6 months, that I would be needing your services as an HR for 6 months. The rest of the duties can be managed once again. So this is a lock-in period, a 6 months lock-in period for him acting in the role of HR. There are various lock-in periods that are supposed to be there in an agreement. Talking about notices, powers, and veto. Notices basically just refers to how you're gonna communicate with each other. If you want to send a legal notice, if you want to do it through email, if you want to do it over WhatsApp, which I wouldn't really suggest, but it's about how you communicate amongst each others. Powers is something which I think we have discussed earlier a lot of times, and veto is a call. Let's say where I would give an example so that you would understand how important is veto. Let's say there are three partners, and two partners currently hold the signatory authority for the current account, and the third partner does not hold it. Sorry. Okay, I did not actually click the mute button. Anyway, so in this situation where two partners have the signing authority for the bank and one and the other partner does not, and now let's say the pandemic has arrived and you need to pay salaries. You have some money, but you have earlier decided that you will use this money for marketing during the pandemic. But you also need to give the salaries of your employees, otherwise you will end up losing them. Now two partners decide that, okay, let's give them the money from the money that has been saved for the marketing budget. The other partner says, no, I don't want that. And now this one partner who says that I don't want to pay the salary is also the partner who has the signatory authority for the current account. Now two partners who are in favor of the decision are still not going to be able to make that decision. Why? Because they do not have a decision making system in such stages of impasse. This is where a veto power would come in. So you need to be prepared for such situations early on. Negotiations and dispute resolutions. So I really don't suggest people to go for a dispute resolution mechanism with the court. But it also changes from industry to industry. Also changes with the dynamics of the co-founders, the number of partners, and a lot of things. So I would want people. I would want the co-founders and the partners to sit with each other and decide, do they also want to negotiate before the court? I mean, it can ultimately go to the courts. The courts will, of course, decide. But do you really want to get into that kind of litigation? Do you want to spend time in that? Do you want to spend your money in that? Or would you want to run your business and communicate with your partner, be upfront with your partner, and move on with the business? So there can be clauses for negotiations even before you move with dispute resolution. There can be a million ways to negotiate and you can always pen it down, but it is always suggestible to keep the ends open so that you always have the flexibility to pick one resolution mechanism over the other. Jatin, I'll be moving to the next slide. Let me know if there's anything that you need to speak about.
Okay, so maybe so we are getting lots of questions from the audience as well. So we'll conclude the presentation and then we'll move on to the question from the audience, because I can see there are many interesting questions that are there, like that we really would some really important and relevant question to the session. And more are coming, like as we are
All right.
speaking.
So should I conclude? I think we're good to go and take the questions, because a conclusion would take time to recapitulate everything. So what do you suggest,
Okay.
Jatin? Let me know.
Hey,
Yeah.
let me interrupt. Sorry, guys. I'm one of the co-hosts. So why don't we? I think this topic is a little more interesting, and the audience are a little more eager. I hope we can extend for another 5 to 10 minutes, just so that we can cover a little more content and the meat. So why don't we extend a little more, if we can?
All right, Jatin. So and Kumar, I am available to do that. How can we ascertain whether the people who are watching
Just
us?
continue. Just continue.
All
If
right.
you have anything, just continue.
Wonderful. So I think Kumar, what I had to say is that ultimately you need to discuss things with your partners. No matter how many people are there in the business, you need to discuss everything with your partner, because they're always going to be there with you in that decision making. And trying to recall the story that I spoke about in the beginning about that friend who turned into a sworn enemy, right? So if you don't play your cards right, if you don't understand how the law can protect you and how the law can help you and your business both, you might end up losing your friend and your business, as it has been said again and again over the period of this discussion. So I think that should be sufficient to conclude with this particular slide, and this must be the point where we can further discuss the questions which people have.
Okay. Okay. Before we move on to the question, I would like to understand from you, like the business and the law is considered a mind to mind thing. But in your last slide, you mentioned like it's a heart to heart conversation, that's need to be done. So
Right.
can you share some more perspective on that?
Right. So basically, as I have seen, I've drafted a lot of co-founders agreement. I have colleagues who have also drafted a lot of co-founders agreement. So we often discuss how things could have been saved, how a lot of heated arguments could have been saved if they would have just had a conversation about this with a cool mind in the beginning of the business. Because when the problem actually I mean, when you come face to face with the problem, you are in a situation where you have a lot of anxiety. You are in a situation where you might have trust issues with your partners, right? So you should be prepared for that. These things, they are all based on emotions, anxieties, and the decision making. No matter how much we teach people to be practical, no matter how many times you tell people that you ought to be practical and you ought to be logical, this never happens. Why? Because ultimately everyone is a human being and human emotions are inevitable. So this is where I think a legal professional's help would be good. This is where an expert's advice would be something which you can make use of. So that's what I had to say about heart-to-heart conversation. You have a heart-to-heart conversation with your partner, and if you're not able to have it with your partner, probably you have a referee or an umpire who can help you see things clearly and who can be impartial during the discussion, so that you don't feel that somebody's against you, or that your wall is against the back. So that's why it's important to open your hearts to your partners, because after all, they are your friend, right? And you need to save your business and your friend both. So that's what I wanted to say.
Awesome. Thank you very much for sharing your perspective on building things for long term. So
Thank you
now
so much.
we'll start taking questions from the audience. So there's a question from Suresh.
All right.
So the question is, in case of a deviation from a contractual terms, what is the enforceability of the contract between the founders?
Right. So if anything goes wrong, let's say you have had a co-founders agreement in place, and all the five essentials have been fulfilled, and you feel like your partner is not standing up to the terms, you can always go and read the clause which tells you how to resolve the dispute, right? So this is one way how you can ascertain what you're supposed to do. And then let's say the clause reads that either you can go for arbitration or you can go for the code-based mechanism depending on your jurisdiction. Let's say if you are in Delhi, and let's say particularly in Delhi, you are in Rohini. So you are supposed to take that take that agreement for an argument before the district courts in Rohini, which has a jurisdiction to decide that matter. Another option would be if your dispute resolution clause talks about arbitration, then you are supposed to either go to an arbitration institute for the dispute resolution, or you are supposed to appoint arbitrators on your own if you are into making the frameworks on your own. So basically, either arbitration or courts, or if the agreement suggests anything before doing these two things. So let me know if the answer is not satisfying enough and if it needs more discussion.
Okay, so in your opinion, let's like one thing is going to the court and resolving the conflict. So from a psychological perspective, in your experience, what you have seen, like when a well thought agreement is in place, is there is there changes, or in terms of maybe percentage or numbers, that you see those kind of conflicts happening less as compared to when
Of course
there
that
is
is
not
there. Of course that is there. Of course that is there. So at times the number comes back to normal when you decide to have a co-founders agreement even at a later stage. So I think you can probably, if I'm not really sure if giving a number would be the right statistics or the right way to put
Mhm.
it. But talking about the psychological perspectives, it gives you a sense of relief. It relieves the insecurity that you might have, that you cannot trust your partner, right? Trust is something which comes into play only when you are in dire circumstances, right? In your everyday life, you do not really need to think about trust that often, right? The question of trust comes in when there is a situation which you need to tackle. So if you have a co-founders agreement in place, you know what to do. There would of course be a psychological effect to that.
Great. So we'll take another question from Mr. Kaushik. So he said, does the division of decision making need to be absolute, since the decision making competency might be across multiple divisions for the co-founders, like that?
Right. So everything can be laid down. Let's say let's say I'm the founder and Mr. Kaushik is the co-founder, and I have an expertise in law, and Mr. Kaushik has an expertise, let's say, in UI UX design. amongst other things, right? I'm not just saying that this is the only expertise he has, but he might have other expertise as well. But I am the one who is able to better frame legal opinions in a situation. So I think this can be decided, but then again, there can also be an opportunity where Mr. Kaushik can have a veto or veto to call off my action. Let's say as a lawyer, I might be under the impression that my legal decision is always going to be good. However, Mr. Kaushik has a different opinion, and he has seen something which I haven't, and he is able to decide that okay, taking this legal step would not be beneficial, and we might end up messing up things. So now this would be Mr. Kaushik's duty here to decide early on that if there is anything like that, Mr. Kaushik should be able to have an upfront discussion with me, and then we must be able to come to a conclusion. And let's say if I am adamant on taking this legal decision, and Mr. Kaushik does not have the veto, and we get this decision in writing, at any point of time, if anything goes south, Mr. Kaushik won't be liable because he tried to explain things to me, and I will be the one liable, and I will have to make up for it. There can, of course, be things to manage that at any point of stage in time.
Awesome. So it empowers you.
Right.
Great. So we have a question from Bhavi. So it's regarding, when, let's say, a co-founder wants to exit. So
Okay.
what are the things, that are in scope of a co-founder agreement that can consider those cases, like, while making one?
Okay, so if a co-founder wants to exit, there can of course be a clause for that. As we discussed about vesting, you can have a lock-in vesting period where, let's say, you decide that over a period of this many months they will have this much equity, or that when they leave they will leave this much equity, or they might have to do this or that. There can of course be clauses for that, depending on the factor that you cannot force anyone to do anything, right? So let's say I provide legal services to Bhavi's startup, right? I'm sorry if I'm mispronouncing the name. Please pardon that. So if
No problem.
thank you so much. Thank you so much, Bhavi. So if I'm providing legal services to your company, and I am a co-founder, and let's say I have 10% equity, and now I want to exit, and you think that you really will not be able to do business without my consultancy or my services, you really cannot go to the court to force me to provide you consultancy, right? Because even if you do that, I might end up giving you substandard consultancy, right? So what you need to do here is you need to make the terms in such a way, you need to have that faith and trust in your partner that he will work with you. And if he wants to exit, you need to give him that freedom, right? That has to be there. There might even be a possibility where Bhavi or anyone, basically the co-founder, any of the co-founders might want to exit. So you also need to keep that exit plan for yourself. So it has to be mutual.
So, and we have a question regarding force majeure. So
All
it's
right.
like, so what happens to the money invested in the company, and things like shareholding, and so what should be noted down in the agreement?
Right. So co-founders agreements premise does not really deal with what happens to the money, right? It is amongst the partners, right? The money which is there, which we're talking about, which has been invested, is the company's money, right? So that is altogether not a part of this. In fact, we have an investors agreement for that, and it is being dealt with that under that kind of an agreement.
Great. So we have some more questions. So one question is, when a dispute happens between founders, do employees have anything to defend themselves? So where do we draw the line between the founders and in those sort of legalities?
I think we could do a little better with a more detailed question in this sense, because as I earlier spoke about it, that it is only between the co-founders. The employees should not have anything to do with it, right?
Okay. We have an interesting question from Mr. Mahesh. He's asking, what are the things we need to look into a co-founder agreement if in case of married couples getting into a business?
All right, this is a very intriguing question. So I think you can decide the rules early on, and the dynamics now become a little more intense. In this situation, this is something which not a lot of lawyers will tell you. This is one way to get a prenup. In India, prenuptial agreements are illegal in India. This is one of the 5 essentials which the Contract Act talks about, right? We read the 5th essential, that it should not be barred by the Contract Act. So basically, the Contract Act has said that you cannot get into prenups, basically. So this could be one way to get into prenups. You can divide the personal assets as well in a co-founders agreement. But coming back to the question at hand, the discussions have to be very upfront. You'll have to decide the work hours, and let's say if it's between the spouses, right? You need to decide who the way you divide the time, the way you treat each other during the work and outside the work. So that is something that has to be discussed, and we can find out a way to get that on paper. However, the terms, the way the clauses are decided and the way the law works remains the same. So essentially, it will still be the same things, which will be there in any other co-founders agreement.
Okay. Okay. So before we move on to the next question, I would like the audience to, to like have some more information regarding the services that are, being provided by Law Briefcase when it comes to a co-founder agreement. So you can get, you can get one-on-one consultation with Siddhant, let's say you want to, later on have the agreement in place, but you want to understand some things around the agreement, so you can have one-on-one conversation with him. We will help you to get that set up. And also he provides a package in which, he will so he will be giving you all the services, consultation and an agreement in itself. And he'll be helping you throughout the period of making that agreement. He'll be ready to discuss things with your co-founders as a team, as an individual, and answer all of your questions if there is any. So this is the standard price that is being provided by the Law Briefcase. And for this event, there is a special discount that is being offered to the participant of this event. And we have decided to keep this, this discount live till midnight today. So we really encourage you to, go ahead, have some quick discussion. If you are at a stage where you are considering having a co-founder agreement, have some quick discussion with your teammates, and So we'll be sharing the link again in the group, and now we will go ahead with the questions. Yeah. So on more questions, so there are some questions related to the exit, of co-founders. So what happens to a startup when such an event happens?
Jatin, so I think I need you to repeat the question once for me.
Just a second.
Sure, please take your time.
Yeah. Meanwhile, if anybody, in the audience have a question, they can, type it, or they can raise their hands. We'll be more than happy to discuss, some specific things with you. So we're running a little short on time. So we'll be in 5 minutes, we'll be wrapping up the session. And yeah, so this is the discount coupon that you can avail. And yeah. Okay. So now Mr. Kaushik has a question regarding the agreement. So is there any condition when it comes to the number of pages? And also, he is a company who is, he has bootstrapped the startup. So we want to understand what is the scope of the proposal that is being provided by Law Briefcase.
All right. So I think it really does not matter how many pages long it is. What matters is that everything has been discussed in detail, right? However, it changes from industry to industry, the length of the discussions. But then again, we understand that it's always going to be between the co-founders, and we always know the premise of the discussion is about the powers and roles. So I understand that it really does not really matter how many pages we write.
Sorry, my question was regarding the service you guys actually provide. So does it have a limitation on number of pages or something like that, or is it for one whole agreement?
Right. So that's exactly what I'm trying to explain, that the number of pitches really do not matter.
Yeah.
We don't have a limit for that.
Okay, okay. And related to the bootstrap, my question was related to the previous question I had asked, where how do you distribute the money in case of being bootstrapped? How would you actually go about deciding if some money is being put in extra by some other partner?
Right. So that's a very good question. So basically, back then when this question was asked, I thought that we were talking about the money that has come from the investor. So let's say, being a co-founder, I have invested some money in the startup. It's just gonna be like it's in every other partnership. The money that I've invested in will come back to me at a point decided, either in the agreement or mutually decided at any time, but between the partners. So it's very flexible. You can have interest rate over that. You can decide to not have interest over it. It's amongst the partners. There's no particular law about it. A general law which I think you should know is that uh, that if the loss hasn't the sharing ratio of the loss hasn't been decided in the agreement, it's gonna be equal to the way you will be sharing profits. But then again, it has nothing to do with the money that the partners have invested in. That is subject to mutual discussions, whether you want to have interest over that money when you get it back from the startup or the other partners, whether you want to just have it back after, let's say, 6 months, or let's say you want to just put that money in and receive the company's services for your own benefit. Anything could be possible.
Okay, thank you.
You're welcome. Hello, Jatin.
Hello.
Hello,
Yes.
please continue.
Yep. So we have a question from Shiv. He's asking, can the same agreement be implemented if new business is added to the previous business? If founders and co-founders are same in this case, and so, or there is a need to draft a new one?
Okay, so now I think the business can be modified without changing much in the co-founders agreement, because it's again about the powers, roles, and responsibilities. But I understand, as you expand, as you scale up, things are going to change, right? So there might be reiterations required. But then again, when you decide that you are going to these things in a startup, you can also decide what else and what other things can you do, and we will prepare the draft according to that. That will come under the part where we exercise due diligence and we consider the force majeure.
Great.
And
I
if
hope,
it's
yeah.
and Jatin, I'm sorry to interrupt. If it
Yes,
relates to the service, I think we already have two revisions to the final before the final draft. So I think we will be able to cover that.
Great, great.
All right.
So I think we are through the questions now. Like we have
Alright.
answered all of the questions, and now we'll be doing a short poll, regarding this session. So I'll be launching the poll. I encourage all the participant to go ahead and participate in the poll. Thank you. And meanwhile, if anybody has any questions, you can put it in the chat window, or you can raise your hand if you want to discuss it. Yeah. Thank you. So Siddhant, so now we'll be concluding the session. So is there any one thought that you want us all to like close this session with? Like what is there is one thing, one piece of advice from a wise man like you? What will it be?
Okay, that is a lot of pressure to put on my shoulders. But then again, if I have to give one piece of advice, is communicate. Please communicate with your partners, with your co-founders. uh, talking, not only talking about business in general in life, you need to communicate. It really is the key to everything. You really cannot read minds. I cannot read yours, you cannot read mine. We only have words to express ourselves. We need to choose the right words, and we need to speak with our partner so that we understand what is going on their mind, and we need to choose the right words to put that in paper, and we also need to choose the right words to discuss with them. You don't really want to hurt your partners, but then you also don't want to stay insecure, and you also don't want to breed contempt amongst each other. So please communicate with your partners, please talk to them.
Okay, that's a good piece of advice. So thank you everyone for joining us for today's session. And Siddhant, we really understood some aspect of where the law meets the emotions, and why is it important to make a good agreement, and how you can save your friendship.